Rachel Carlson, Scott Kelly from League of Minnesota Cities, and we've had a lot of questions regarding different things that are happening at meetings and open meeting law and all kinds of stuff. So they're here to talk to the group, committee members and the council about those topics. So, Rachel.
Hey, I wanted to welcome you all to tonight's presentation. I'm Rachel Carlson. I'm the Loss Control Manager for the League of Minnesota Cities Insurance Trust, which means my job is basically to prevent lawsuits. I started out as a city attorney a number of years ago and moved into this position. I just wanted to remind you that this is really your member dollars that are paying for us to be here tonight. As we're not typical insurance. You don't just buy insurance like you do from Geico. It's actually a membership pool. It's all of your money. It's all of your well-being. It's all of your resources pooled into there. And as a result, we're able to come out and talk to you when you need help, when you have questions, when there's a particular topic you want to know about. The topic that we're going to talk about tonight is the open meeting law, data practices, and those are some questions that we typically see around good council management. And they're also an area where we do unfortunately see lawsuits. So we have a specialist on staff. Scott's about as good as it gets when it comes to issues like data practices and the open meeting law. We've been working together for at least 7 years, and he was working for the courts before that. So Scott's going to handle the main bulk of the presentation. Afterwards, Scott and I will both be here for questions. And you can always call the Loss Control Department at the League of Minnesota Cities Insurance Trust. If you individually have questions, maybe you're too shy to ask them tonight. I doubt that with elected people, but just in case. So we'll be here for you, and thanks for having us up. We always appreciate when people are very proactive, and when they have concerns, they seek out the education that they need. So thank you.
Well, good evening. We want to say again, thanks for the great turnout. Nothing like spending your Wednesday night hearing a couple of attorneys talk, right? And reminds me of a story that I heard when I went to school not too far from here in St. John's. A story about a teacher, a banker, and a lawyer who all found themselves at the pearly gates one day. They get up there, and sure enough, there's gates, and they were just amazed. And all of a sudden, poof, out of nowhere came St. Peter. And the banker says, well, that's great. I want you to open the door and let us get in. St. Peter said, well, it doesn't work like that out here. I'll ask each of you a question. And if you get the question right, you get to come on in. So St. Peter leans down and goes to the teacher first. He goes to the teacher and says, there was a terrible shipwreck about 100 years ago. What was the name of that shipwreck? And the teacher said, Titanic. Yeah.
Sorry.
St. Peter thought he was giving the teacher an easy question. Gates opened up and the teacher walked right on in. He goes to the banker. He's a banker, a little bit more tough, difficult question. Says, how many people were actually on the Titanic that day that died? And the banker said,
About 1,200.
about 1,200. He opened the door, and St. Peter wasn't terribly happy because he was a banker, but that's the rules is the rules. And so goes down. Next to last is the attorney. Goes the attorney, leans in real close, and says, "Name him." So if you're not terribly on here, a couple of attorneys talk. Don't worry, it's nothing new, and it's not going to be new that day when I get there as well. But it really is a pleasure to be here tonight and to talk to you. As Rachel indicated, really what we're here for, both as the league and as staff that choose to work there, is because we want to help our cities, we want to help our elected officials, we want to help the people that are appointed at the boards and commissions to do their job. And the open meeting law certainly is it's a significant concern that cities have over and over again. If you have attended any of our seminars in the past, perhaps our loss control seminars, or the annual conference, or the regional meetings, or whatever it might be, you may have seen something on the open meeting law. And if you go in the future, you're probably going to see something on the open meeting law again. Staff are always rotating, elected officials are always rotating. And these questions, even though they might seem easy to understand in theory, when we sit down and we try to do it in practice, it can be a whole lot more difficult. So for the time that I have with you today, we're going to talk about the open meeting law most specifically. We'll spend about the first half to maybe 2/3 of the presentation going about what the statutes say you have to do when you're going to get together. Spend some time as well talking about meeting rules and procedures and decorum, things that more are discretionary decisions that you make as a body, how we want to interact, what we think is appropriate or not, who's allowed to participate with us and so forth. Things that really are up to your own discretion. The statutes, the state law doesn't really say much about it. I've thrown in some specific instances or concerns, things that come up from time to time, but as we have there as well, we have time for questions, and if you have questions that pop up throughout the presentation, please don't hesitate to raise your hand and ask. Now, why do we worry so much about the open meeting? Why do we consider it to be important? Why was I invited here tonight? What is the concern? Well, from a more general concern, this law, the Open Meeting Law, as well as our Data Practices Act, conflict of interest laws, gift laws, laundry list of things that are in place to govern how cities operate or how elected or appointed officials operate, is because they're safeguards, if you will. But for the most part, they're not to protect us as the council member or the committee member, but they exist to protect the city itself, which really is, it's a separate entity. We don't think of it, as a business for lots of good reasons, but it's a municipal corporation in many ways. How 3M or Target or any business else like that operates and has rules it has to follow, the city in many ways is the same way. It's there to protect them, but it's not necessarily there, again, to protect you as the individual. And we also worry about the open meeting law because there could be some significant consequences to us, both financial and both in terms of reputation, if there are violations of the law. But the open meeting law becomes a little bit more important when you think about how a city and city council or its committees makes decisions. When we think about the roles of government, particularly when it comes to city council, we often use the terms power, authority, and responsibility. What authority do you have when it comes to being a member of the council, for one? Well, you have ultimate authority, you have ultimate responsibility, ultimate power, rests on the whole council. You control the city's checkbook. You adopt city ordinances that have consequences to all the people that work or live within the city. The city through you enters into contracts or other collaborative relationships. The city council ultimately does the hiring and the firing. Now that doesn't mean that the staff that we have, that we don't rely on, that doesn't mean that they don't help us make those decisions. They do, and they should. And we don't take those recommendations in blindly, though sometimes in some cities that happens as well. But since, as the council as a whole has to be together when we make these decisions, the rules and requirements that cover the open meeting law, or the ones that we make ourselves, have additional or added importance. But while decisions are made by the council, or perhaps a committee, we can't ignore the role or the importance or the responsibility of the individual members. As individuals, we need to be well-versed on city business. That's a responsibility that we have. We have a right as well as a responsibility to participate in meetings and vote when that time comes. We also need to act as a liaison between the city and its residents, its businesses, and any other interests that come into play. What other things do you do as the council or as a committee member? What are the councils that you've worked for? What other responsibilities do they have?
Me?
Yeah.
All of everything that he's talking about.
Yeah. Cities are interesting things. They are employers, they're utility providers, they provide recreational services. There's lots of things that cities do. But what we remember is that we aren't alone. We don't have the ability to exercise that authority as an individual. That power resides with the whole council. We talk about all the different responsibilities that you have because of the office, because you were elected, or because you were appointed. But it can be difficult to comply with all these responsibilities. One of the reasons, I don't know if the color comes out as well in this room, but it's a gray bar. A lot of the laws that we deal with, they're not as black and white as perhaps we would like them to be. It's more of a gray area. These laws, the open meeting law or anything else, They're subject to our interpretation, and that's not ever very helpful. And we have to try to figure out what something means. The recommended or the right way that we're supposed to conduct ourselves, and well, it might be contrary to the past city practices. We've been doing it this way forever. And it might be very contrary to how we operate in our personal or professional lives. And I've run a business for 20, 30 years. Here's how we handle things. You're telling me I can't do it here. Well, it might be right in that context, it might be right in that setting. But because of some of these laws we have here, a different response is potentially required. And another problem that we have is these laws are always changing. The open meeting law hasn't changed so much as some other things, like the Data Practice Act, which changes sometimes significantly every single year. Legislature tinkers with it a little bit here and a little bit there. When we try to make a conclusion about what we're supposed to do, we have to take this gray law and we have to take actual facts and we try to have to mesh them together. And again, that's not helpful. We want to know how to do it this time and do it next time and do it time again. And it's not always so simple. We have to get assistance sometimes to know what we're supposed to do, perhaps what we can't do. And then finally, a lot of these laws that we have that govern how elected or appointed officials are supposed to do their jobs, well, we have to choose to comply with them. There's a speed limit between St. Paul and Little Falls, so up on 94 and up on 10, and I had to choose whether or not I was going to follow that today when I got here. All right? Now, there could have been a consequence for me if I was choosing not to follow it at the wrong time. Well, wrong time from my perspective, but it was a choice that I had to make. And for everyone in this room, we have to make this a priority to ourselves, and we have to choose to follow what the law says we're supposed to do or not do, or how we're supposed to do it. The Minnesota Open Meeting Law is found within Chapter 13D of the state statutes. How many people there have actually ever had to pull out the statutes, pull out the Open Meeting Law, and read what it says? See some hands. It's about 10 pages of text or type. The Data Practice Act goes on for about 200 pages, and there's another 30 pages of rules to try to interpret the 200 pages. So it's a relatively thin document as laws go. But I can summarize it probably in about one sentence. When a public body meets, it must provide advance notice, and it must allow the public to attend. Well, that's pretty straightforward, right? But does that bring up any thoughts or questions to you?
How much advance notice?
How much advance notice? Sure. Yeah. When I look at that, or I think of what I just said and prepared myself, I wonder, well, one, what's a public body? Two, what does meet mean? Three, what's acceptable notice? Four, does the public always have a right to attend? And five, why did I put an asterisk in there?
Personnel. Meetings on.
Personnel is a great example, yes ma'am. Okay, so the purpose is pretty straightforward. We don't want our elected officials to meet in secret and make decisions outside the public's eye. The public has a right to be fully informed about the decisions that their council makes, decisions that affect the quality of life in the community, the types of services the city is going to provide, how much those are going to cost, property taxes, implications, utility charges, license or permit fees. We elect a small number of people to make these decisions for us, but even though we elect them and they have the responsibility when they're sitting at these chairs, as a member of the public, I have a right to know what they're doing, and I also should have the ability, because I can come when they meet, to try to detect whether or not there's any improper or questionable decision making that's going. And through that, not always directly, and we'll get into that, your citizens, your business owners, they have a right to present their views on city issues as well. They might not be able to speak at each meeting, but most, and I believe you do as well, provide time for citizen comments. They contact their elected officials by phone or by email, or they see at the coffee shop, and they can impact or give their feelings on what they think you're doing or not. And if you're going to assume anything with the open meeting law, you have to assume that everything's open, because it's right in the name of the law. Now, if the open meeting law applies to meetings of public bodies, well then the question should be, well then what is a meeting? Well, if you took a look at the open meeting law to try to find out the definition of what a meeting is, you're not going to find it because it's not in there. They didn't define what a meeting is in the open meeting law. But our courts have, from time to time, had to interpret what that word or those words mean. And they define a meeting as an event where a quorum of the public body is present and city business is either discussed, information is received, or some type of action is taken. A quorum is a majority of the body, the minimum number that are necessary to start a meeting in the first place. For your city council here, what's your quorum?
5.
5, because you have an 8-member quorum, and that's how you go. Do you have any members of your planning and zoning commission here? How large is your body?
7.
7, so your quorum is?
4.
Yeah. If you couldn't figure it out, it's half plus 1. And city business is broad. It's a broad term. It's probably as broad as it could possibly be. And again, it's not necessarily limited to times where we're actually voting or making decisions, but can include times where information is received or discussed. Who must comply with the open meeting law? Well, the first section of that law provides a laundry list of the groups to who it applies to. It specifically in the statute applies to the city council, but it goes beyond the council and includes other public bodies, such as the city EDA or HRA, perhaps the Fire Relief Association, they're even covered. But it also covers committees, subcommittees, boards, departments, commissions of the public bodies. So like your planning commission, your zoning commission, your library board, if you have a parks board here. The language is so broad that it really could cover any group that your city creates. What you can't do, the way that they wrote the law is, we just can't give a certain committee or group or subcommittee of our council this unique or crazy name and say, well, it's not written in the law, so we don't have to follow the open meeting law. Whatever you come up with, it's probably covered. So, city council meetings, special meetings, public hearings, work sessions, executive sessions, retreats, our quarterly coffee get-together with our residents. For purpose of the open meeting law, it doesn't matter what you as a city call it when you get together. If a quorum is present again and a city business is being discussed, the open meeting law applies. They're all just, if you will, meetings for the purpose of that law. So we can't make a distinction for a work session, it's not covered, or it is covered, retreats, whatever it is. But there are 5 different types of meetings in the open meeting law. These classifications affect the type of notice we're required to provide, perhaps the subject matter we're allowed to discuss, or even access to the meeting by the general public. And the 5 types of meetings that exist are regular meetings, special meetings, emergency meetings, a continued meeting, or a closed meeting, and we'll look at them in turn. The first type of meeting is the quote-unquote regular meeting. Regular meetings are held at a date and a time that you provided in a schedule. A schedule that you've adopted is on file at City Hall. So if I want to attend a city council meeting, I'm new to the area, I don't know when you meet, I can come to City Hall, I can talk to Lori or Dan now, and I can say, well, can I get a copy of when you meet, your regular schedule? Somebody go to the file cabinet or perhaps print one off their website or off the computer and hand it to me, and I'll know when you're going to meet. You certainly can provide additional notice when you're going to hold a regular meeting, a regular work session, whatever it is. You can put it on your city bulletin board, in your newspaper, or on your website, which I know you do here. You're just not required to by the open meeting law. Having that schedule is all that's required. And again, regular meetings aren't limited to the typical meeting we probably have, we imagine in our head, where bills are paid, resolutions and ordinances are adopted. Do you ever hold work sessions here to just talk about things? Yeah. You can have a regular, and I think you do. You can have a regular work session. Every once a month or once every other week, we have a quote-unquote work session where we talk about things, we perhaps get reports, but we just don't take any votes, I assume, correct? Yeah. Regular meeting. Regular meetings are open to the public. There's nothing in the statutes that would limit discussions to agenda items, though agenda is a common thing. Agenda is a common thing because it helps us do our work and make sure that we get everything done that we have to do. It can help streamline things, make sure all the business is done, hopefully in as expedient amount of time as possible. But if you need to add something outside your own rules, which we will get into again, you just add it. Open law doesn't care about your agenda. That's what a regular meeting is. Now, a special meeting is a meeting that is held at a different time, a different day, or a different location than is provided for on that regular meeting schedule, the one that you have on file, and I can come get a copy if I want. Because they fall outside of that schedule, there are a few steps that need to be done before we're allowed to hold them. 3 days notice is required for a special meeting. Now let's say, for example, our council met last night, and as everyone's walking out, everyone's gone, we figured we forgot to do something pretty critical. We can't wait till the next meeting, a couple of weeks or a month away. So what we can do is call a special meeting to tie whatever loose ends there are up. So when we count these days, when can we hold the meeting? You can't count the first day, but you count the last day, unless the last day falls on a weekend or it falls on a legal holiday, so you have to push that back. So if we call a special meeting today, audience, when's the first day that we can hold it? Monday. Monday would be the right day. If it was a week from now and we had to do this, well, we'd have to push it back to Tuesday because of the Labor Day holiday. Now, we do have to provide notice of a special meeting, and this notice either has to be posted on your city bulletin board or the meeting room door if you don't have a bulletin board. And in addition to that, it has to be mailed to anyone who has made a request, and you have that on file, to be given notice whenever a special meeting is held. And that notice can be specific. It could be just for the city council, or it could be just for one of your boards or commissions. But you have to do those two things. An alternative to that, if you don't want to do that mass mailing, which may or may not be an issue here, you can certainly publish it in your newspaper. That any members of the council, or the committee, I suppose, needs to be provided notice at least, of that meeting at least 1 day before. If the council gets notice 1 day before, that's sufficient for their notice for purpose of the open meeting law. Third type of meeting under the open meeting law is for an emergency meeting. There is a method, there's a means, legal means, to hold a meeting with little to no notice if the circumstances require it. You know, if there's a legitimate emergency, and I'll stress the legitimate part, you don't have any requirements to publish or post notice of that meeting. The city is required to make a good faith effort to notify any media outlets, your newspaper, perhaps any radio stations that, again, have on file notice that we want to be notified. What is an emergency? Well, I think, you imagine a natural disaster is probably the common example. A tornado comes through town, or, cities that deal with flooding, all sorts of snow emergency potentially. Those are the easy kind. I think when you try to determine whether or not you have an emergency for the open meeting law is whether or not you can wait those 3 days. If you can wait those 3 days and nothing worse is going to happen, we'd like to deal with it tonight, but we got to, can we wait 3 days and will nothing more happen? If you answer yes to that, well then perhaps you're trickling out of that emergency definition, and you'd have to follow the requirements for a special meeting more generally. And, because it's a significant caveat or exception to this law, we always suggest, like we do for lots of things, that you should really get the okay from your city attorney before you hold something as an emergency meeting. And certainly, as with a regular meeting, or as with a special meeting, emergency meetings are open to the public. Then there's the continued meeting. Say we're discussing a very contentious issue. Perhaps there's a controversial subdivision request. We started the meeting at 6 o'clock. It's going to be 11 o'clock at night. We still have a laundry list of agenda items that we need to discuss. Everyone's getting tired. Perhaps everyone's getting tired of each other, right? And we're not going to be terribly productive if we keep this meeting going. Well, we can continue that meeting to a different time and a different place. And we don't have to follow those notice requirements for a special meeting so long as the time and the place of that continued or that next meeting, we established it before we left, and we recorded that in the minutes. Now, I think the way that works, when we think about the notice that we provide to the public, is I know, Lori, when does the council regularly meet here? What day?
First and third Mondays.
Okay, first and third Mondays. If I want to go to council meetings, I regularly want to go, and I will either want to come and watch it here or watch it on your cable access channel. I know that those days it's going to happen, and I can schedule my life around it. Well, you're going to have a continued meeting or a special meeting, and you're going to do it on a Thursday. Well, I bowl on Thursday, right? And so I might want to know what the purpose is, and we'll get to the, for the notice. I might want to know what's going on, I might want to know what's happening, so if I need to, I can change my life around. Well, for purposes of the continued meeting, I was there. I was either in the room or I was watching. I should know when the next one's going to be, and I think that's the purpose of the intent behind that exception. And as the case with those other meetings we talked about, the public is certainly able to attend a continued meeting. They're always open to the public. And finally, some meetings, as you do know, can be closed to the public. But the exceptions that are provided in the open meeting law are quite limited. They're limited both to type and they're limited in scope. There are two situations where the open meeting law says that a meeting must be closed. It uses the term shall, and whenever you see shall in a statute, it means must. The first type is if you need to consider preliminary allegations against an employee, or really I suppose anyone else that is subject to your authority. The employee is the typical one. Statutes say that type of meeting has to be closed. But it also provides that if that employee, him or herself, wants that meeting to be open, well, it's going to be open. If it's an open meeting, certainly the public has a right to attend. And the second type of meeting that has to be closed, if you're discussing certain not or non-public data. Now, the Data Privacy Act is an hour-and-a-half meeting in itself, and I don't think we're going to hold you that long tonight, but certain types of information, perhaps information that would identify victims of sexual conduct, internal affairs data dealing with your police department, perhaps medical records, or certain minor exceptions. If you're going to be talking about things like that, and I don't think you have to talk about that much, quite frankly, those types of meetings have to be closed. So two types of meetings that have to be closed. And there's a handful of exceptions that within the council's discretion, you can choose to close a meeting or not. If you have any employees here represented by a trade or labor union, when you're preparing for those negotiations for the new collective bargaining agreement, your discussions to determine how you're going to handle those negotiations, that setting can be closed. If a meeting is closed pursuant to the attorney-client privilege because you are, or there's a strong likelihood that you're going to be sued for some reason or another, the meeting can be closed for that. Performance review of an employee, council can choose to close that, but the same way with the misconduct, if that employee, him or herself, says, no, I'd rather have it open, you can have it open. Purchase or sale of real property, you can close a meeting for that. I think that one's kind of obvious. If you're thinking of buying my property because you want to extend a park or something else like that, I can just sit in the back of the room and I can hear, well, we'd like to pay 80, but we'll go up to 100. And you go up to me and say, oh, how about 80? I'll say, no, how about 100? Okay? You're going to be negotiating against yourself, so there's, I think, an obvious exception for that. And the final one is to deal with security briefings, or reports, or other emergency response related procedures or data. You can close a meeting for that. When we close these meetings, and it's a relatively new provision in the open meeting law, you're required to record audio or video that meeting, with the exception of the attorney-client privilege. And based on the type of exception, sometimes after an event has happened, that tape becomes public. Do you have your police officers represented by a union up here? Yeah. Okay, so next time you negotiate that collective bargaining agreement, and if you close a meeting to do your planning session, your strategy session, once you've adopted that collective bargaining agreement, the tapes are public and they stay public for a certain period of time. With the purchase or sale of real property, once you either buy the land or you decide you're not going to do it anymore, well then at that point those tapes become public. For some of these things like the personnel related stuff, either misconduct or performance review, that information keeps that classification of that data and might likely be considered private for, well, maybe hours, but based on what's on the tape, then you decide who can see it or who can't. If you're going to close a meeting, how we do it is kind of critical importance. We didn't bring a lot of materials today because we weren't sure how large a crowd was going to be, and we were trying not to waste paper at the league, but we have lots of materials, and as Rachel indicated, we can provide them to you. But one of the memos that we have is called Meetings of City Councils. It provides a step-by-step process for each of the types of closed meetings and what you need to do. But essentially, you always start as an open meeting. All right? Even if you're calling a special meeting where you think or you know you're going to close it. Perhaps there's allegations of misconduct, and we've called a special meeting, it's potentially, I guess, an emergency meeting as well, but we call the meeting, this is the only thing that we're going to do, and we're going to be closing it, and it might seem like a waste of time to have everyone come and be walked out, but we start as an open meeting. We always start as an open meeting. And for a practical sense, because the council has to make decisions as a whole, you vote to close the meeting, and collectively you decide, yes, based on the subject matter and our rights, we're going to close this meeting, this is what the group runs. And then you have to explain on your record the specific statutory grounds that allow you to close the meeting and the subject that's being discussed. For example, pursuant to Minnesota Statute 13D.005, subdivision 3C, the council is going into closed session to evaluate the performance of our city clerk. And then following that, you go into closed session, and then, again, like I suggested earlier, you have to tape that. Is there a requirement that you generally have to record your council meetings? No, there's not. It's something that I think most cities do, particularly if you have the caption and it's on cable, it's right there. But it also helps staff as they prepare their minutes, and if there's any question about exactly what had happened. Certainly everyone's memory is great, but everyone's memory can be different. If we can pull out that tape and we can listen to it, that can help things significantly. As I suggested at the opening, there can be significant consequences for violating the open meeting law. There's a penalty for intentional violations. There's a fine of up to $300. And you as an individual have to pay that. The city can't pay that on your behalf. The law specifically says that's improper, inappropriate. If it happens 3 times, if there's 3 intentional violations, you lose your office, you lose your seat. And if you want to pile on, if you will, the person who alleges the violation and brings or initiates an action, well, they can be awarded attorney's fees up to $13,000. Now, these could be paid by the city, and the insurance trust does have open meeting law coverage, but more than anything, these things just look bad. All right, they bring into question the decision-making process, and even if nothing really, if you will, a big deal happened when there was this violation, you start losing the community's trust on little, insignificant, inconsequential things. When you're making a decision when you really need the community to be behind you, it's much more difficult for that to happen. Now, there are lots of common or recurring issues that arise around the open meeting law. There's about 5 or 6 that we probably get the most questions about. We're hiring a new city administrator, and we're going to go through an interview process. And since this is going to be, if you will, the top staff member we have in the city, I think each of the council members are probably going to be interested in who we pick, right? If we want to interview, whether or not the open meeting law applies depends on whether or not a quorum of the public body is doing the interview. There's no exception. If the quorum is doing the interview, the meeting is subject to the open meeting law. It has to be noticed and it has to be open. Now, sometimes cities and city staff or council, they have some concerns about that. I think understandably so. We want someone to come in to work for us, and we want to have a real conversation with them. We perhaps want to get into some probing things. How comfortable will everyone be if it's open and people can come in and out while that's going on? I think it's a legitimate concern, but as a practical one, and if the staff in here want to comment based on their own experiences, I think a lot of times they know that getting into this, that they work in public, that they're going to, for a lot of what they do, they're going to live in public. And if it's going to be open, and if the whole council is going to interview, for most people, so be it. And if they're not willing to do that, who knows how good of a fit they would have been for you in the long run. Now, if less than a quorum of your council is going to do this, you're probably not going to have a violation unless a quote-unquote serial meeting has happened. And we'll get into what a serial meeting is in a little bit of detail in a couple of slides. So what happens if a quorum or more of your council attend the same church? Do we have that here? Is the council here? Is 4 or 5 people in the same church? Very small town, one church. It can happen, right? A lot smaller than Little Falls. But how about if you're in the same cafe at the same time, you happen to all be at the gas station, a quorum of you at the same time, you all are at the high school watching a football game on a Friday night. Is that a violation of the open meeting law? No, by itself, that's not an issue. The open meeting law doesn't necessarily, one of the elements of the open meeting law is to have that quorum present, and you might have that, everyone's at the high school football game, but the other elements, under my description, is missing. You have to be discussing city business. Now, every city is different, and the dynamic of every council is different, and sometimes when a group, the only thing that they have amongst themselves is that they're on the council together. Sometimes whenever they see each other, the only thing that they have to talk about is, well, the council, all right? And so, we also worry about perception. Perception of impropriety in the same way we talked about, minor violations, if you will, an open meeting law violation, when we're talking about something really trivial or minor. Well, you do have to be mindful of how it looks as well, and someone might just see, well, look over on the other side of the stands, there's 5 of them, they're sitting together. Well, they gotta be talking about city business. Even if you're talking about grandkids and kids and, what you do in your regular job and things like that. So, you have to be mindful, but barring a city conversation, that's not an issue. Questions often come up regarding what we do before or after our meetings. Council tonight, the meeting is supposed to schedule 6, but, everyone's in their seats, quarter to, and perhaps everyone just starts talking about what's on item 6 or whether or not there's going to be an issue here or issue there. Is that a problem? I see some nods. Yeah, potentially it is. If you go back to our brief definition of a meeting, you have a quorum present, and they're talking about city business, item 6, so on and so forth. The only problem is, even though you're where you're supposed to be, the time that you said you're going to be here to talk about city business, that hasn't happened yet. And I gave a speech, open the meeting law speech one time to a city, and I gave it twice. I gave it before their council meeting, and I gave it afterwards, because they wanted, like we have here, they wanted as many people to show up, and they had planning commissioners and things like that. And I went through the speech the first time, and I get to this part, and you got to be careful what you talk about before or after. And for the hour of their council meeting, I wasn't going to go anywhere, so I just sat in the back, and council started trickling in and milling into their seats. And they started talking about item 6 and item 7, item 8, and somebody kind of noticed who was sitting there before. I think he just told us we're not supposed to do that. It's a natural thing, folks, just to talk about things that you're here to talk about. And the idea that, well, we're here where we're supposed to be. It's only 5 minutes before. Again, I agree. It's potentially a trivial, tic-tacky, thing. But the law is written how it is. Arguably, again, it's written so if I show up exactly at 6 o'clock, I'm not going to miss anything. And the same goes, if you will, for post meetings as well. We adjourn, we all go together to the coffee shop, or perhaps we have a beer after a meeting where we rehash what happened. If a quorum goes out together after the meeting and is essentially convening another one, there could be a violation. Now, a colleague who has been doing this for, 40 or 50 years, he told us that one of the cities that he either knew of or represented at one time, they would formally recess their meeting to the local bar. Now, was that okay? For the open meeting law purposes, it might have been just fine. Now, you do that 1950 or 1960, no one might care, everyone might expect you to do that. Sentiment might be different in 2012.
I have a question.
Yeah.
How about a quorum traveling together? In a vehicle, van, going to, I'll use the Mississippi Headwaters Board meeting as an example. 5 from the council or 3 from the county board, traveling to save the county or the city money, et cetera, et cetera. I know that's a real touchy subject. And is it not recommended to do that?
We wouldn't recommend it.
I'm sure you wouldn't recommend it.
Yeah. Well, I think you, as you summarized it, I think you kind of hit all the issues yourself. Now let's just, again, two things could happen in that car ride. Either you talk about the city business or the subject of that group, or you don't. Now, if you talk about the subject of that group, I suppose you could turn yourself in. They might not. But the other thing is, in the same way we talk about just the appearance of impropriety, someone can see you all pile into a car together and drive off. They're just going to assume, lots of people are just going to assume, particularly if they have an issue with what's going on, decisions that the city's making, or decisions perhaps that they have with you personally, that you're doing something wrong. And any time that you can get into a situation to just flat out avoid that from happening, you want to avoid it from happening. Now, again, someone would have to be able to prove that you did what they say that you did. While we were together in this car, you were talking about city business, and I didn't have a right to attend, I didn't get notice of it, so on and so forth. So, again, it's something that you do want to avoid. Whether or not it would actually be a violation would depend on what you actually did while you were in that car together. Any other questions on that? Or I brought the term up earlier, but say, for example, I usually say 2 or 3 because most cities have 5-member councils, but say in your city 5 is a quorum, we have 3 people, perhaps 4 people that are together, they're at the coffee shop, they're meeting, perhaps they're talking over the phone, and they're talking city business. Is that ever a concern? I see some nods. Does anyone think, no, that's not a concern?
How it's perceived.
Well, perception is a big part, but this can actually go a little bit farther than that. The open meeting law applies by itself to a quorum. So in your city, 5 members of the council or 4 members of your plan and zoning commission, whatever committee, whatever that quorum is. If you're under that, that meeting in and of itself might not be an issue. But the 3 of us are talking together, and all of a sudden I talk to another member who wasn't there, and I says, what's going on? What did I miss? Well, me, Tom, Jerry, and Susan, we got together and we were talking about this, and here's what they think, and here's what I think, and so on and so forth. Well, now we have potentially 5 members, or perhaps another person gets added on and we have a 6th member. Or, and we'll get to that a little bit later, what about, email and things like that? But meetings of less than a quorum, if they're held serially, if you will, one after another, they might be a violation of the open meeting law. And one of the things that they're going to look into that is if there was an intent to avoid having a public hearing or to otherwise fashion some type of agreement. And again, I know this is one thing that we think about our personal and professional lives. It kind of seems archaic, We have a full council meeting every Monday. We're here for 2 hours. We're here for 2.5 hours. We're here for 3 hours. If we can talk a little bit before then, maybe hash some of these things out, well, then we're not going to be there so long. Maybe we can actually, cover more things. We won't stretch ourselves so thin. Maybe there's some merit to that, but it's just not allowed by the open meeting law. So, be very careful. Now again, if we want to talk about appearance, and you're absolutely right on, and appearance covers lots of these things. As much as you can, city business, any city-related business that you do in your role as a council member, that you do as a role as any committee member, should be done when you're sitting in these chairs. As much as you can do that, that's what you do. If you're missing a meeting and you're trying to get apprised by something, again, by itself, talking to one council member by itself might not be an issue, but it's clearly not an issue if you talk to Dan or you talk to Lori. Dan and Lori are covered by the open meeting law. They can tell you what you missed. Might give you a copy of the tape. They can keep you abreast. Okay. Computers are convenient. Some people might have learned to type typewriter. Some people remember we just had pencils and pens, right? But that's not what we have anymore. And computers are, because they're so convenient, they are potentially the easiest way to create an open meeting law violation or an open meeting law issue. A few taps on the keyboard, I hit send, and I send an email to everyone that's here tonight. Thanks for coming. I appreciate the hospitality. There was very good questions. I'm going to do that follow-up, and I'm going to get back to you. hey, but I'm on the council and the same thing. Everyone. I just read the Star Tribune and it talked about this city in the metro area that just put a smoking ban in their parks. I think we should consider that here. I don't know if you have that or not, but I think we should consider that here. Maybe that's, let's talk about it. Get a reply from one person, but not just a reply to me, but a reply to all. I think that's a good idea. Someone else comes back. I think that's a horrible idea, so on and so forth. A computer can be an intentional conduit for a violation, but it can easily, just as easily, be an unintentional violation. So, like anything, we suggest caution. Lots of cities have adopted policies that deal with how they are to communicate amongst themselves via email. Do we have that here?
Not a specific policy.
Okay. We have a model, and it's a pretty strong one.
Yep.
We'll forge a copy after that. And if something happens and we want to talk about this agenda item, I want to talk about something in our next council meeting. I found all this really good information. The packets are already out. I don't know if you still mail them or if you do them by email, but let's just say you mail them out, or the cops, drive around and send them out to your houses. And they do that Friday night. It's Sunday. I want you to have this for Monday. I forward it to Lori. I forward it to Dan. Dan or Lori just sends it to everyone else. We understand that we're not going to reply to this. Lori or Dan, they keep a copy of everything that we have, so the data practices concerns or record retention concerns that we have are covered in case someone wants to know. I thought I got a copy of everything that you had, but all of a sudden here that is. You're covered that way as well. So I would strongly think about adopting that and following it. No replies, no forwarding emails amongst ourselves. These concerns that are easily done through computer, probably most easily done through a computer. The same concerns apply if you're using phones or if you're using US mail, but they just, from a practical nature, that just doesn't happen much anymore. No mail law applies to any joint powers we might create with our neighboring townships or our cities or our schools. And it can also apply when our council is perhaps invited to a county board, to discuss perhaps a joint road project or other endeavor that's either going to work together on, they're going that's going to impact us and they want our feedback and they're inviting the whole council to be there. Now, if a quorum of our body, our city council, or our planning and zoning commission, whatever it might be, is going to attend, and we are going to participate in that discussion, city business, we're going to be having our own meeting. Even though the county board has noticed and posted their meeting, we're going to be having a meeting of ourselves. So all the requirements that we need to do for a special meeting, we would want to do that in that situation. Now, what if you just want to watch? The Planning and Zoning Committee is going to be doing something that I'm particularly interested in. Perhaps it's in my neighborhood. Perhaps, it's something that I'm really interested in. And in some cities, I don't know if you have it here, some council members are members of the Planning and Zoning. Do you have that? Yeah, 2 members, 3 members? 2. Okay. Well, again, based on the uniqueness of your 8-member council, it's more, you're actually in a better situation because, you have that extra person. It might be tougher to get 5 people in a room than 4, but, you have the 2 members that are sitting there, and 3 other members want to come, so they show up and they sit in the audience. Do we think that's a violation of the open meeting law? Who would say yes? I think it's a violation. Who would say no, I don't think it's a violation? Who would say you're an attorney, it always depends? It's got to depend. Both hands up in the air on that one. Yeah, it depends. Now, I told you earlier when we talked about the open meeting law and what the Supreme Court says, it says, oh, you're receiving information, you're deciding information, you're making decisions. Well, I thought I hit the first one there. I'm receiving information. It's city-related information. The Planning Commission's doing it, but I'm sitting here. Well, there's not a case on it, but the Attorney General has the ability, the cities can request an opinion and they can give opinions on municipal or other related issues, which doesn't have as much force as a court case does, but it's significant. And if you follow it, you don't have a penalty for following it. This issue's come up before, and the Attorney General said, well, it does depend. If you're just sitting out in the audience and you're not actively participating, you're just there, I'm just sitting by myself, that's not a problem. But if I interject myself into the conversation, or if I'm brought into the conversation, which can easily happen. You know, if you have that quorum that comes up after that, it can happen. Where I live, I'm the chair of one of our advisory committees, the park committee, and we had some issues with the park debt fee. A really contentious issue, particularly for a park and rec committee, right? And it went from our committee, it went to the planning and zoning committee, and we knew some members were going to talk, and I come in, I sit in the back of the room, and I notice, 1, 2, 3, 4, 5, we're almost all there, you know? Well, I got up and I made sure I sat away from everyone else, because if someone shouldn't be violating the open meeting law, it shouldn't be the guy that talks to them about saying, tell people what not to do or not do. But the group was good. And they kind of just by themselves, they just kind of sat in the back. They were kind of away from each other. I don't think I didn't, but I don't think the group talked about it up in the parking lot afterwards. We didn't participate, so we weren't having a park committee while the planning commission was going on. But what's the easiest thing we can do if I know that I want to attend, and I have a pretty good idea that Bob and Joe would want to attend as well? Let's let Lori know and let's call a special meeting. Post it. If we don't show up, it's no big deal. But again, it's just one of those protections that we can put into place. So attendance alone probably doesn't meet that definition of a meeting, but if we participate, it looks a whole lot more like one of those meetings. Now, if you read the open meeting law again, in the first section, it's a laundry list of all the groups that it applies to. And it has some pretty broad language in there for boards, committees, subcommittees, and things like that. Told you before, it's all inclusive. It should cover about everything. But when it has come up before, when some of these unique, if you will, groups, sorry, it's a subgroup of the council that has been designated or delegated to do something, perhaps on behalf of the council, perhaps a fact-finding team, and to come back, well, how does that apply? Is that an open meeting law concern? And quite frankly, there isn't many cases on this. But some of the cases that have existed have been favorable in some of those situations. For, again, we have an 8-member group and only 2 of them are as a temporary nature or something like that. That might not be a group that were the long-term effect of the open. There isn't the long-term nature. There's not a standing committee where the open meeting law could apply. But if we have a situation where we are setting up formal committees, we have that park board or that planning and zoning commission or anything that really is formal, that's meeting regularly. The idea is that they should be posted, notice, public has a right to attend. If it's more of an, if you will, an ad hoc or temporary committee or task force, perhaps it's something that was residents themselves are doing something and we're giving them a room to talk. Main Street preservation or renovation, something of that nature. If it's not our committee, again, something like that. But I think we found pretty regularly, and I don't know about turnout here, for when your committees meet and things like that. You post it, not necessarily anyone is ever going to show up, And so you might be providing a protection or a right or benefit, if you will, to your public to attend something that no one's ever going to attend. So again, that's an open meeting law in about a 45-minute nutshell. We always suggest, we do it by nature, we suggest a conservative approach to a lot of these issues. And if you take a conservative approach to the open meeting law, the chances that you're going to violate the law are going to go down very substantially. When you have a question, whether or not the open meeting law applies to this or applies to that, some of the things that I ask myself or I recommend to people when they ask us is first, this group that's meeting, is it itself subject to the open meeting law? Is it a council? Is it a committee, a commission, something standing, something like that? If you answer yes, it is, well then you go to your second question. Well then, are we having a meeting? Is there a quorum there? And if there is a quorum there, is receiving, deciding, or discussing city business? If you answer yes to those 2 questions, go to the third one. Is there any specific exception, perhaps, that would apply to how we conduct that meeting for public purposes? If you ever have a question, that's why you have a city attorney, that's why you pay membership dues to us as well. Do we have any questions concerning what the statutes, what the state law says about meetings? What we can do, what we can't do?
I have a question about an email coming or being sent to everybody before, say, an HPC meeting about
Mhm.
the Pine Grove Park.
Yeah?
And everybody at that meeting having that prior to the meeting. Is that a violation?
No. Just based on that, a one-way communication from someone who may be subject to the open meeting law to other people who may be subject to the open meeting law, by itself, that's not a violation. It's the interaction. It's the interaction that becomes an issue.
So if someone would comment back or whatever.
Commenting back would be the problem.
And if there are a lot of people in the hallway out here and in the parking lot afterwards, is that a problem?
What are they talking about?
Of the meetings?
It's like anything. These things don't necessarily exist in a vacuum. A whole group of people, 8, 7, 5 people anywhere, is not necessarily ever an open meeting law concern. It depends what they're talking about. If the subject matter and the number of people that are together meet the meeting definition, well, then that's a problem. If it doesn't, then it's not.
And how about a large group of people from either city staff, council members, board members, whatever, attend, say, something out of Camp Ripley, an open house, or Larson Boat Company down in St. Cloud, and it's only for staff or board members or council members to attend those? What about the public perception with something like that?
Well, I guess perception, I think the answer to that might be rhetorical. How the public feels about something or other is how the public feels about something or other. If they have a bad perception about it, well, then they have a bad perception about it. The question is whether or not it violates the open meeting law, which can be two different things.
Would it?
Yes. The open meeting law is specific to when a quorum or more of the governing body is together and they're receiving, deciding, or discussing city business. That's what that covers. It doesn't cover any of the other situations where the public might not like what's going on, but it's based on subject matter or based on the number of people that are participating. It's not a meeting for the open meeting law purposes.
So say, for instance, Larson Boats gets some kind of tax subsidization or special interest loan or whatever from the city, and all these staff and city council members go to this meeting. Would that be a violation?
What happened at the meeting?
I don't
I
know,
can't
because the
answer.
public's not welcome to it.
Well, then I can't answer that.
I think, first of all, that, when you call me, that could mean we were invited to, like, last night, it was 100th anniversary, and it was special invite, but that was also posted in our, our meeting, that council was going for that. It was a 100th anniversary celebration for Larson Boats that the city council was invited to.
Social events by themselves are not covered by the open meeting law.
Other than that, there's only 3 there.
Yeah.
That was even covered as well. Other questions?
If a community member or a council member is aware of an open meeting violation, what is the protocol? What do you do about it?
Well, that's an interesting question, Councilmember. The penalty and the remedy for violation of the open meeting law are of a civil nature. If you went to the county sheriff or you went to your police department and said, they're meeting at the cafeteria and they're talking about city business, go get them. He would, or she would, kind of shrug their shoulders, and it would be outside their purview because they deal with criminal law. You would have to get, there's a mechanism to get a non-binding opinion from the State Department of Administration. They have a division that deals with the open meeting law. And you could ask for an opinion. Open meeting law opinions are not free. I believe they're $300. I don't remember the number off the top of my head, but is it $200? Thank you. And they could tell you whether or not they believe, based on what they know, how it's described, and they allow the city to provide a counterpoint as well, whether or not they thought it was an issue. But for the purpose of the fine and for the purpose of intentional violations, that person, him or herself, would have to get an attorney in it to get an action going in district court. It's a pretty significant standard burden that person, him or herself, would have to do that. Now, some of the situations where there have been some, more likely than not, perhaps the media, the local media would have an issue that the Newspapers Association has an attorney, and they might go through something like that themselves. But the answer, the roundabout way to get it is you'd have to go get yourself an attorney and do an action like you do for lots of things. Yeah.
Just as a clarification, for instance, Morrison County Planning Commission members meet as a body out at a site to look at an upcoming variance or conditional use permit request, and they publish it in the paper. Now, is that considered a special meeting and then the 3-day notice applies?
Sounds like.
Okay,
Sounds like.
just to clarify.
Other questions? Now, yeah.
I just would like to ask a question. Can there be more than one compliance officer working for a government body?
What do you mean by compliance officer?
Someone who is responsible for data practice laws.
Probably responsible authority.
Each city is required to have one responsible authority. At that responsible authority's discretion, they can appoint designees for particular, perhaps, departments or particular subject matter areas. There could be a designated person, say perhaps for the police department or public works department or anything else like that.
I was told by a man by the name of Jason at the data practice, the iPad place in the cities, that a city had to have a public access data procedure, a compliance officer, and a responsible authority. That's state law.
Yeah.
So the compliance officer can be different than the responsible authority, or,
Can be the same as well.
but the city has to have both.
Yeah.
And who would be that person here now? Lori, are you still that?
Until the council appoints someone different, yes.
Okay, I got a question, and I talked to you about this before we started. Several years ago, an article came out in the newspaper where 5 council members kind of put it as we, and all 5 of them signed it. And it was city discussion. Would that be in violation?
Well, I guess depending on how they got to that point. What makes that a little bit more difficult is potentially an argument, I suppose, could be made that when they did that, they were acting as individuals and not in their roles as a council member. I think that would be hard to justify. But potentially that's an argument that could be made. But by itself, any type of city-related activity or action that's done outside of a, well, not necessarily a council meeting, but a noticed and posted venue, potentially could be a concern. That's a little wiggly, but that's as far as I can go without going through it.
The information that she's talking about was all discussed in public meetings though, and then just recapped in that letter?
Well, I guess that would.
It was all public information.
It might be public information, but it's the issue in that situation would be what was the venue where those folks got together, if they got together, and put that again together and sent it out. Now, yeah, we might have a meeting on Monday where we're all together and we talked about something, and then on Tuesday, some of us get together and we talked about the exact same thing. Well, it was done in public on Monday, but that doesn't excuse what happened on Tuesday. Could still be a concern.
So, and when a person gets elected, at what point do they have to abide by the open meeting law then?
First Tuesday of the year, whenever you take office.
Says they've got to be sworn in first.
So if you were to have an announcement in the paper based on some conclusion, you could instruct staff at that public meeting to devise from the public record the points that were made at the public meeting, and then that should be fine, right? Because it's a recording resulting from the open meeting.
Well, staff can certainly direct, or council can certainly direct staff to make a report or publication for their newspaper.
Okay.
Other questions? Now, what I want to end with, and we're going to go relatively quickly, not because of the time, but I suppose because of the nature of I guess the second part, if you will, of this presentation. The first part, really dealt with what the open meeting law says, which deals with the mechanism of, if you will, having a meeting and what that means in regard to providing notice or having a schedule or whatever else it might be. Really have no discretion in that regard to what the open meeting law says. If you want to meet on a day, it's either part of your regular schedule or you follow whatever means or mechanism or procedure is required by the law to meet on that other day. But the open meeting law really doesn't get in, state law by itself doesn't get in, and you're a charter city, so you're having unique elements of that as well, on what we're actually going to do when we get here on Monday and we're going to have our meeting. So there are lots of practical considerations, I suppose, that can help make a meeting a good meeting or bad. And lots of times when we talk about, well, how can we have the most effective meeting possible, what kind of recommendations or tips do you have that we should follow? We're going to go through a few things. Me and Rachel talked about this before, and here's some of the highlighted things that I think anyone thinks about when they're talking not just about a council meeting, but just when people get together and try to work. But as I'll probably say 4 or 5 or 6 times, you kind of got to figure out what works best for your city and your council or your committee, and then make that work for you, because what worked very well in perhaps Brainerd would be helpful to consider here, but based on your dynamics, it might not work very well at all. So again, you have a tremendous amount of discretion in determining, what you're going to do when you meet. You're not going to look at the statutes and tell you what you're supposed to do when you sit in your chair and it becomes 6 o'clock. There's lots of reasons why we don't look at the statutes, or we can't look at the statutes for the actual meeting protocol. Every city is different. It's a different size, different population, it has different needs, it has different priorities. And again, it's particularly true for a charter city like Little Falls. Each charter, you'll find a lot of similarities in almost every charter across the state. You have some unique things as well. The role of your mayor, the size of your council, and that's in some ways very unique. And so, in the same way that you need to decide, well, how large your police department is going to be, funding is going to be, a big consideration of that as well as crime, or how many parks that you're going to have. You really need to figure out what works best for you when it comes to your meetings. Now, I think we take this for granted, the following. When everything is going smoothly, when everything's going well, we're all getting along, and we all, for the most part, are seeing everything the same way. But working with other people, regardless of the context, can be very difficult, right? And when we haven't dealt with personal or perhaps business-related issues in quite a while, we seem to always be voting 8-0 or 7-0 the same way. When conflicts do arise, sometimes they just seem or they just feel worse than they actually are. These are the decision-making process in itself is a conflict. And when you take into consideration above that everyone on the council or everyone on the committee has an equal voice, you don't have that hierarchy. You can have a meeting with the department head and everyone else, and they can give their opinions, and if the department head or the administrator or whoever else it might be says, no, we're going this way, well, we're going to go that way because that person, the buck stops with them. Not that way with your council. Equal voices, equal right to vote. Things can become more difficult. So, again, it's important, I believe, to remember that there is perhaps an inherent or underlying conflict whenever we are involved in a group, and whenever that group has to get some things done. That conflict, the nature of the work in and of itself, requires debate, it requires discussion, it requires negotiation, and it requires compromise. Now, before I worked for the league, as Rachel said, I worked for a judge, and one of the times when we were on civil rotations, attorneys would come in very nice suits, and they would sit across from each other at the table. And before the hearing was convened, meanwhile, didn't fly, so they could talk about whatever they wanted. And they would talk very congenially to each other, talk civilly, nice. And as soon as the hearing would start, they wouldn't be swearing at each other, but they were very eloquently saying how lousy or how much garbage that person's argument is, or their cases, and they take shots at each other. And then when the hearing's over, they shake hands and they walk away. It's somewhat of a nature of what we do, though not everyone does it quite well, right? People still take things to heart. There's lots, the dispute resolution industry, if you will, has really expanded over the last 20 years. Our courts have been, overwhelmed, and they've looked at that, and ideas of using mediation or arbitration or all sorts of things. It's really an industry that's thriving, and regardless of the context, be it a divorce or be it a group that needs to get together better at work, whatever it might be, there's an understanding that it can be difficult and things. There was a book that was written, 20 or 30 years ago now, about negotiations and the idea of getting everyone to yes. If you spend any time with labor negotiations, this book is almost like a Bible, and it talks about how to get everyone to a position where they're happy and they can say yes at the end. I think that's a great idea, but in theory, I don't think it always works. And I think it's more realistic to suggest that we might not get to yes on everything, but we have to move more to okay, I understand. It's not what I want, but I'm not getting what I want this time around. I had my say, I tried to be as articulate as I could. This time around, it's just not going to happen. So how do we set up a dynamic where we create a venue where we can try to get to okay all the time and get to yes as much as possible? Well, we start with our bylaws, our rules of procedure, whatever we call them. It's important to review these things, and it's important to create them if they don't exist. I know Lori had forwarded me some of the materials that you already have about how to conduct meetings and what motions are, and there's good things there. I suppose they can always be, there's always room for improvement. I would suggest that whatever materials that you have, whatever bylaws or policy, it's kind of a reflection of what our common or shared values and expectations are. And when I say ours, they might have been adopted 10 years ago and no one that's currently on the council was on there, perhaps only one member, but we're continuing bodies, and they might reflect what happened in the past, and we will tinker and change them if the future or current needs require. And there isn't a golden set of rules to make your problems go away. But I would suggest that you need to have them be as simple as possible. I looked at your rules, and I noticed that one of the last caveats, if what we have isn't covered within our abbreviated form, we'll follow this, Robert's Rules, we'll go to this. And even one of the memos that we have, it's included within that as well. If we can't find it here, we go to Robert's Rules. Folks, I would suggest that Robert's Rules for what you do is more or less garbage, right? It is hundreds of pages, simplified and abridged, right? And it was designed for more of a parliament, like parliament or the legislature or a union meeting where everyone that's out in the audience and the decision makers that might have a more prominent role up here, they all have equal say, they have an equal right to speak, they have an equal right to make debate and all that. And it doesn't work for a group of 4, 5, 7, or 8 members. I'd take that up. And you want to have something that you can easily understand. Rachel worked on a handbook a couple of years ago for mayors. The Mayors Association had a request, they wanted a mayor's handbook, and we made some really good materials at the back of that document. A very simplified rules of procedure, an even shorter cheat sheet that indicates what's debatable or not. We forwarded a copy, but we can, again, send every individual a copy if they'd like. Make it as simple as possible so we understand what's going on. You don't want layer after layer of motions and concerns that don't help your meeting run any smoother. You only create a situation later, well, I don't know if we got that second or it was a motion to rescind, who can bring that up or not. Lots of cases you don't need that, so don't worry about it. But you have rules of procedure in place to keep the things moving, and hopefully you're using them even when situations don't arise, so if discussion needs to be tightened or someone, quote unquote, needs to be reined in, you're going to just utilize and rely on the policy that you have in place already. Decorum as well is very important. And it really needs to apply to everyone that's involved, be it the members of the council or the committee, to your city staff or your consultants when they are in and speaking, and it needs to apply to members of the audience as well. In my opinion, I think the first bullet point is the most critical. The idea that someone needs to be recognized before they can speak. I know from some of the advisory, albeit but committees that I have been on, when there's just that idea that one person needs to be recognized or take the floor before the next one can be recognized or take the floor, you can eliminate the shouting back and forth, the discussions between members that can get off topic, that can get personal, people's feelings can get hurt, so on, or even worse. And having that idea where you need to be recognized can do a lot about that. But staying on topic and having the person push to stay on topic whenever that's necessary. The idea of refraining from private conversations and what that can do. Do you want to share a story about that?
Way back when I was lawyering, I had a counsel, and I will not name them. This was before internet and but it was before everybody had the internet on their phones. And we had two women on council who really liked to talk to each other, and they really did not like the third member on council. And it started out they would kind of gossip and make snide comments to each other about this third person. And then the mayor split them. So suddenly they were sitting on with somebody in between them. And so this is again before your smartphone. They started to pass each other notes. And the notes were not of a profound nature. Some of them said, God, his nose is really big. Or, gosh, where did you find that sweater for tonight? And somebody, the newspaper reporter in the front seat one night, noticed that they were passing those notes back and forth and actually submitted a data practices request to the city to get those notes. And then they were public, and they were in the newspaper. The newspaper actually photocopied them with their handwriting. And so those two council members looked like schoolgirls. And they were very smart women. They just were having a couple snarky days, and it was a combative council. But, you know, in the days of iPhone, and we get calls on this, in the days of, some people have their packets are computerized, so they have computers in there. Keep in mind, if you are emailing each other back and forth, gosh, he won't stop talking, or I hate his sweater, all of those things are subject to the data practices law, and somebody can request them, and you might have the embarrassment that these two poor women had, and they didn't run again, actually. So that's my story from my days of lawyering. Keep in mind, it's public. It's happening at a meeting. In fact, somebody could demand it at the meeting and say, you know, the audience wants to see what you're doing. You feel like you were in the third grade.
So if someone was on their smartphone or whatever, a person could ask for that information from someone's phone?
Potentially.
Yeah, the Data Practices Act, deals with, as one would expect, government data. And there's a distinction between what we would classify as government data, dealing with their role or their interaction with the city, versus what would be considered personal data. If the city allows Lori and anyone else to use the computer to check their own private email, or perhaps put personal things on the calendar, a dentist, got to pick up the kids, or anything else like that, that wouldn't be subject to a request because it's personal and falls outside it. But your smartphone text, if it would be classified as government data, sure. And you got to be particularly mindful. Again, don't want to go too far off tangent. Do you provide I don't remember, do you provide your council members city emails?
No.
You might want to, in the future, you might want to consider that. Because if anyone ever does make a data practices request, and you use the city email, it's a whole lot easier, perhaps less invasive personally, for them to check that than my own one. But yes, if people are working at home, and there are things on a home hard drive, if it's government data and it doesn't fall within a protection, then yes, potentially it could be, well, you could request anything, but the actual idea of someone getting that, awesome. Yeah.
There's a really good article in the League's magazine's last magazine on emailing and that kind of thing.
Yeah. And just, my last one, if you have more questions, we'll answer, but the last note about that. One of the things about the Data Practices Act, that just like the open meeting law with smartphones and everything else that we're dealing with, is that it was built at a time when we were still, using file cabinets and pieces of paper. And we're using file cabinets and pieces of paper in the same way that we used to. And the way that we maintain emails or records on our hard drives or on zip drives or anything else that might be like that, you got to be particularly mindful of, because things like that, they can be subject to very significant, costly, and, personally, intrusive requests. But like Rachel said, have people turn off their cell phones, And even though you probably don't see it as much in a written decorum policy, but important nevertheless, again, because we're doing work and we're trying to get to maybe or okay as much as we can, when someone's talking, listen to them. You can read certainly, but I hope you don't have it here, but if Google YouTube and look for clips about councils that don't get along. Right? And not only will you find yelling and shouting, but you'll see when one person talks and people will figuratively or literally turn, and they won't listen. And I'm sure if you followed up with those things, that person, that relationship is not going to get fixed. And have an open mind while you're listening. Even if you generally don't agree with someone, you have different ideologies, they make a good argument, and it's the right argument for the city. It's the one that should be adopted. And then you really need to have a good presiding officer. Being on the council or being on any of your committees, the presiding officer has a lot of influence on how meetings over the course of the year, or a particular meeting, if it runs smoothly or if it doesn't. They are the one to make sure that everyone efficiently gets the right to participate, and they can also keep things moving and things like that. I've been on committees where the presiding officer, usually it's a vice chair or someone else like that, they step in because the chair is not in that day. And it's tough, right? I'm sure we've got people that have been presiding officer either here now or in the past. It can be difficult. And not everyone can do a very good job at it. In most statutory cities, by default, it's the mayor. So whoever's elected to that office, they're going to be your presiding officer, and either they're going to be good at it or they're not going to be good at it. I believe you have some discretion through your council president. I don't know if you do it on a formally rotating basis or if you vote or things like that. I would always just try to make sure that someone who's confident in themselves and would have the ability to keep things moving and keep everything tactful, that those are the people that you look to. And even if they've done it before, you've done a good job and we'd like you to do it again. Now finally, citizen involvement can be an opportunity, sometimes a concern as well. In state law, there is generally no right for a member of the public who comes to your meeting to say anything, to participate. Certainly there are certain things where there is a public hearing requirement. Most of it's land use, zoning changes and things like that. No. Do you have a municipal liquor store here?
No.
If you did, one of the unique ones that I always remember is if it's losing money 2 out of 3 years, you gotta have a public hearing. Doesn't mean you gotta close it, but you gotta have a public hearing. But for the most part, how, when, why, and what nature you allow the public to participate is up to you. It's up to you. It should be pursuant to your policy, and it should be applied uniformly to people. If you're going to have time at the front where you sign in, you get 5 minutes, you say that, then you sit down. Or if you're going to actually, you want to provide some give and take between the council and the people in the audience, well, quite frankly, you can do what you want. But if you're going to do that, you really got to make it uniform. All right. You can't just let Tom in the back of the room talk to the council, even if Tom makes really articulate, makes very good sense, and then prevent everyone else that you don't want to do that. Have some type of policy, perhaps have them provide written notice or get on the agenda, but create what you want and stick to it. Apply those rules equally and neutrally to everyone. Again, chance for questions on anything. Well, we might not have questions tonight, but questions arise from time to time. And there really are lots of avenues to get help. I don't know if anyone is relatively new to the council or new to the commission, but your staff, your city attorney, should always be a first step. Pay membership dues for us for a particular reason. Insurance is a big thing, but this is the general advice and guidance. We've seen things from across the state that can provide you insight. If things need to get more formal, or if perhaps things are more contentious and need to go beyond that, people can request opinions from the Attorney General, data practice of the law, opinions can be requested from the Department of Administration. I just suggest you don't take chances.
Do you have a program like this on data practices? Because you brought that up a couple times, you know, that it's separate from open meeting law. So do you do something like this that gives a general overview?
Yeah, we have. I do. Yes, I did.
And also iPad, which is up there, actually has, if you go to their website, has some really good videos that they have made that play live on the website. And you can get all of the basics there. And if there is certainly a pressing city need for more of a data practices speech, we could come up here and do that.
So one thing about the iPad website that is particularly helpful is compared to the open meeting law, where the volume of either court cases or opinions are relatively minor. You know, this law's been around for a while and it affects 854 cities, 87 counties, fill in the blank, lots of bodies that this applies to. And one of the reasons why, when we talk to council about who can ask for an opinion or what to do, it's somewhat prohibitive for people to do a lot of this. Well, there's lots on the Data Practice Act. This iPad website has 1,000, 1,500 advisory opinions on nearly everything.
And they're indexed.
Yeah. And they're indexed.
But we're more than happy to do that, but I gotta warn you, that might be, as our older colleagues